Good afternoon, ladies and gentlemen, my dear friends. We are back to our beautiful subject, remedial procedural law. Because when we uploaded the first version, it looks like we got uh, cut off somehow after we discussed bail. And by impressions, there is a version that was uploaded in YouTube that allowed us to continue with the audio presentation. It was done. But at about I think 14 minutes of the show, if you might call it, the video, including the movement of the PowerPoint slides, did not proceed. So, and many have given feedback to me, and I couldn't understand why that is so. So the way we will do it now is we will run a continuation. We will call this part 2 so that part 1 stays, but part 2 would allow us to pick up where we left off. Perhaps the other way to look at it is I would just run a fresh set, and perhaps because you have already heard me make my sip-sip bola with Dr. Emily Dadson de Leon on the first run, and we will not remove that. I will probably just compress it to so that it doesn't get to be boring even for Dr. De Leon watching it. So without much ado, let us now proceed by saying that we will call this now still remedial procedural law. But when I prepare the title, it will now be procedural bar 2023 remedial law suggested answers. So you will have two files, and this file will be the more later one. We are honoring Dr. Emily Dadson de Leon with this upload of the most challenging exam in the bar examination, that is on remedial procedural law. Dr. Emily Dadson de Leon is the president of the University of Manila. It's incumbent chairman of the Board of Trustees, concurrently the academic vice president, and insofar as I'm concerned, the singular icon, the heart and the strength of the University of Manila. She has been with UM for much more than 40 years, working side by side with then controlling and major stockholder, chief executive officer, and president, the late Virgilio de los Santos. And Dr. de los Santos was very lucky. He's the usual very senior executive who would depend upon feedback and identifying, of course, the critical elements of uh, the business, which is University of Manila. But the one who was getting all of this moving was really Dr. Emily Dadson de Leon. When trouble was so tough for UM by way of the troublesome fraternities and gangs that proliferated in UM, then we used to have flooding right at UM. It was Dr. De Leon who was at the front line of all of this. She was brave enough to even face the troublemakers, and some of them were in the fourth floor throwing literally chairs towards the quadrangle. Doctora was in the middle and was saying, "You try me." She was so the only brave soul in the UM administration who really challenged those troublemakers. And so she was still, of course, very young at the time. Dr. De Leon had the opportunity to go around several very critical suggestions. She started with a very humble role of being the executive assistant of many of the deans. And as you know, this kind of work would allow you to really be exposed to the operations of the individual colleges where she was being assigned. And that also allowed the deans to again be take their sweet time while Dr. De Leon was the one really pushing all the details. There was also a time that she was the UM registrar, and so she knew everything about the administrative workings of the office. But the most shocking to me is because when I joined UM in 1994, UM was not yet, especially, well, the buildings in UM, especially the main building, which houses the office of the president, chairman of the board, and the rest of the deans. The building itself was relatively dark, it gets to be flooded, and it really looks like a pitiful building considering the financial constraints of UM. Little by little, Dr. Emily tried to save precious money and gradually started putting tiles initially on the flooring, on the walls, and it was the offices of the senior executive that she immediately took care of. And then little by little, I noticed that because I was there in 1994 and I was a bar reviewer, teaching also in the regular course. Even the classroom started being spruced up. And so before you know it, the UM, sorry to say this, yung bulok na UM suddenly started, getting to be more masaya, more modern, everything. So today, you walk into UM, you will see essentially the same building structure from outside. Noli Fili building, the main building. But as you get in, just on the entrance itself, you will already see how the tiles were properly installed. The walls have been so improved. And that is all to the credit of Dr. Emily Dadson de Leon. She wanted UM to look like the respectable school that we could all be proud of. We were also very active in the Philippine Association of Colleges and Universities. She was one of the very strong fiscalizers there on possible deterioration of how the campuses of member schools would be acting. And so at one time, she has always been consistently in the board of directors until one time she was elected to the second highest position of being executive vice president. I was lucky to have been asked by both Dr. Virgilio de los Santos and Dr. Emily Dadson de Leon to be effectively her assistant and sidekick in PACU. Because the lawyers would normally sabotage her efforts, and I was given the task of ensuring that the legal bottleneck doesn't happen. And so we are very proud of Dr. Emily Dadson de Leon. I would apologize that I got an old picture when even if I put up her picture now, she would continue to be still as charming and as beautiful. I always kid her by saying, every time we get the presidents of all the university belt schools standing to take pictures, she will always stand up, not only as the sharp-looking president of UN, but the only Tisay, the only good-looking lady who doesn't seem to be also meek and dumb. Doktora is a very articulate person. Americana nga eh. Her father is Dodson. That's why when I joined UM, she was carrying only the name Emily Dodson, Emily De Leon. But you know, every time people would look at her, Emily De Leon, mistisa, maganda, matalino, matapang. So I whispered to her, Ma'am, to really project what you really are, perhaps you might want to bring in really your true surname, which is Dodson. And before I know it, little by little, she started introducing that word, Dr. Emily Dodson De Leon. Yeah, that fits really into the picture. So if I would like to grab credit, it was probably my whispering to her for her to put up her real surname, which is Dodson, to reflect her personality. Here, she would. I don't like to estimate how old was she, but you can see how charming and how beautiful she is. If I were to replace this with her picture now, it would still come out better for a senior citizen like me also. Now we belong to the same generation, but she would continue to give credit to herself. And many of our female students, I personally noticed, started learning how to carry themselves, even if they come from poor families, with humble dresses. They start carrying themselves properly, and because Dr. De Leon becomes the model on which they try to pattern their style of carrying themselves. So Dr. Emily is definitely a tribute to brains and beauty, and she becomes a good example. Kaya I call her the icon of University of Manila. I go around and meet a lot of people who graduated from UM, especially the police officers. How many times have I had to transact with the various police districts, and whenever I introduce myself as Dean Bisquera, University of Manila, I would get an immediate response in saying, Dean, I am a graduate of UM Criminology. Kumusta po si Dr. De Leon? Yeah, automatically. They know her in person. So to them, UM is Dr. Emily Dodson De Leon, and Emily Dodson De Leon is UM. Ganyan ang image ni Dr. And she deserves it. So I'm putting this up as my humble tribute. Matagal na po dapat nabigyan ko ng tribute si Doktora by dedicating one of these uploads on YouTube about law. She is, by the way, part of the field of law. She finished her Bachelor of Laws magna cum laude from UM and proceeded to the Master of Laws, also again magna cum laude. The only reason why she's not a member of the Philippine Bar is when she was about to take the bar, the matter of her being still an American citizen at that time and has not made any of her choices prevented her from becoming attorney Emily Dodson De Leon. Otherwise, siguro, mas kukunti ang trabaho ko sa UM enroll as the Dean of the College of Law. But she really is part of the field and the profession of law, short of taking the bar exams. At a certain point, tinanong ko, ma'am, ba't hindi mo na sinubukan kumuha nung ikaw nag-elect na ng Philippine citizenship? And she said, ay naku din, with all of my schedule, siguro medyo hirap na akong mag-take off for a respectable review. Okay na rin ito, sabi niya. Kulang na lang sabihin sa akin, hindi nga ako member ng Philippine Bar, kaya lahat naman kayo, being the academic vice president and now the president, Lahat kayong mga abogado rito anyway, reporting to me naman. So that is how it is. So without much ado, allow me to now proceed with the subject matter of remedial procedural law. By way of showing what the contents of the 2023 bar examination on remedial law and procedural law is all about, these are the breakdown of the subjects that were given, or the exams that were given in that September 2023 bar exams. In criminal procedure, there were 4 questions that were given. In civil procedure, there were 5, so that's almost a balance of questions in criminal procedure and civil procedure. But surprisingly, and I was smiling because I love this subject so much, 6 questions came out in evidence, and then 1 question in special civil action, and 1 question in special proceedings. I just combined them into one so that you don't have a very cluttered chart here. And legal ethics, there were 2 legal ethics questions and 1 judicial ethics. And so this is how these things would work. Actually, these ones are balanced, but if I remember right, I included the question on legal forms. There was 1 question on the preparing a deed of absolute sale of a piece of land. I already included that as part of evidence because, documents, legal forms are supposed to be the documentary evidences. So without much ado, allow me now to start the ball rolling on criminal procedure. The 4 problems in criminal procedure look like this. There was a question on bail, there was a question on arrest, and there were 2 questions on information. In bail, the problem reads like this. It has something to do about bail on conviction before the trial court. And the accused moves to appeal his case before the Court of Appeals, and he wanted to avail of bail. So problem number 10 reads like this. Angel was charged with murder before the Regional Trial Court, RTC. After trial, the court convicted her of homicide due to the absence of the qualifying circumstance of treachery. She then filed a notice of appeal and applied for bail with the RTC before transmittal of the record to the Court of Appeals. The prosecution opposed the application, contending that the RTC has no jurisdiction to act on the application for bail. The RTC granted the application for bail on the ground that the prosecution failed to prove the 5 bail-negating circumstances. Did the RTC have jurisdiction to act on the application for bail filed by Angel? Discuss your answer. Our suggested answer, no, the RTC has no jurisdiction for Angel's application for bail after his conviction. On appeal, Angel can apply for bail before the Court of Appeals. Obviously, because the nature of a bail is essentially to take an exception to imprisonment, And so while your case is pending, you apply for bail, so you are given the liberty to be outside of what you call this imprisonment during your trial. So the objective of requiring you to post bail is to ensure that you appear in court when you are needed during the deliberation. So that if the case is pending before the trial court, then the application for bail would have to be before the trial judge of the trial court. But if the conviction has already been made, the proceedings will now move to the Court of Appeals. And even if there is no personal appearance technically before the Court of Appeals, the Court of Appeals can still, as an exception, call for oral arguing. So, and that may require the attendance of the accused. And so the application for bail to ensure that that person will appear, if ever asked by the Court of Appeals to appear, would happen. So the application for bail will have to be filed with the court who has already assumed jurisdiction of the case. Under Section 5 of Rule 114 on bail, it says that if the decision of the trial court convicting the accused change the nature of the offense from non-bailable to bailable, the application for bail can only be filed with and resolved by the appellate court. Should the court grant the application, the accused may be allowed to continue on provisional liberty during the pendency of the appeal under the same bail subject to the consent of the ombudsman. So that's essentially the subject matter on bail. And so we go back to our master schedule on criminal procedure, and now we are ready to move to the next question on arrest. The question on arrest runs like this. It is on the service of warrant. It was problem number 11. On October 18, 2021, a warrant of arrest was issued against Erica. At 11:15 on October 30, 2021, police officers arrested Erica at her house pursuant to the arrest warrant. Before arraignment, Erica moved to quash the information on the grounds that the warrant was served at nighttime and beyond 10 days from its issuance. Is the position of Erica tenable? The position of Erica revolved around two issues. One, the arrest was done at nighttime, and the warrant of arrest is beyond its 10-day life. So our suggested answer, no, Erica's position is not tenable. She can be arrested at any time of the day or night. The judge can issue an alias warrant to effectively extend the 10-day life of the original warrant. Take note that the warrant of arrest, as I was already saying on the first question on bail, is to ensure that due process is carried out. So that if there is an information, a case now filed before the court, part of the requirement of due process is before you imprison and deprive the life of the person, before depriving the accused of his right to life, to liberty, or even to property, you are supposed to inform that person. And to inform that person is to bring that person to court. And when that person is brought to court, that is when you say, there is a action against you, criminal action against you, charging you, for example, of, say, theft, or, for example, bigamy, or what have you. The need to communicate is part of due process, because you will now say you are being accused. Then you ask, are you guilty or not guilty? Part of due process. And of course, the person will be given the opportunity to either deny by saying not guilty or admit guilty. Okay. And so that is required. That is the reason why the judge has to issue a warrant so that the arresting officer can now say, hey, you are wanted by the court, you better go there. Now, this person now says that my arrest is invalid because the warrant has already expired. And you very the judge, you will probably nicely say, with the permission, of course, with the indulgence of the defense counsel. The reason why we're bringing you here is to allow you to know that you are being accused, rather than suddenly just sentence you to imprisonment. So we're giving you that opportunity to defend yourself, to deny, and the presumption of innocence is in your favor. But if you're questioning our direction to bring you to court and you're saying you're not supposed to be in court, how will you know that you need to defend yourself? Anyway, for technicality, since you're going into technicality, this particular warrant of arrest has already been exceeded, the 10-day life has been exceeded. No problem. I will give into your technicality. I will be issuing effectively a reproduced copy of this particular original warrant and call it the alias warrant of arrest. So ito na, yung alias warrant. Wala ka ng problema. Ngayon, babasahan ka na namin ng habla under arraignment. So again, for your good. Kasi otherwise, kung ayaw mong marinig na hinahabla ka, kukulong ka na. Wala naman due process. So it is to your advantage na you have a warrant rather than, hindi ako pwedeng arrestuhin dahil lumampas na ng 10 days. That will not happen. That's why there is always an alias warrant. Next, the execution of warrant. The head of the office to whom the warrant of arrest was delivered for execution shall cause the warrant to be executed within 10 days from its receipt. Within 10 days after the expiration of the period, the officer to whom it was assigned for execution shall make a report to the judge who issued the warrant. Ano na nangyari? Na-inform na ba natin para ma-arraign na natin at matuloy na itong kaso at magbakbakan? May kasalanan ba base sa sumbong? Presumption of innocence. So, dapat dalhin nyo na siya rito. So, in case of his failure to execute the warrant, he shall state the reason therefore. Judge, hindi ho namin makita nag-iba ho yung address. Can you give us another chance to find her? Expired na ho itong warrant. Sabi ng public prosecutor, Your Honor, we move for the issuance of an alias warrant. That will be issued. There even instances siguro, pwede sabihin, sige, gawin na natin na abaan natin yung period so that will give you the opportunity to look for us. That is pursuant to Section 4 of Article 113 on the rules on criminal procedure. Okay. After arrest, we go now to the question of information. On the matter of information, the first problem under that is what is called an amended information. Problem number 9. Now it reads, William and several other persons were charged with violation of the Anti-Hazing Act. During their arraignment, William and his co-accused pleaded not guilty to the charge that they unlawfully subjected Carding Cruz to hazing. The information was later amended by adding the suffix the third to the name Carding Cruz. Si Carding Cruz pala hindi pala yung original na lolo, hindi ito pala yung apo. Kaya may Carding Cruz Jr., yung tatay niya, Carding Cruz III, yung apo. Trial ensued without the accused having been rearranged on the amended information. After the accused was convicted by the trial court, William appealed, contending that his right to be informed of the nature and cause of the accusation against him was violated when he was not rearranged after the amendment of the information. Is William correct? Discuss. Our suggested answer is no, William is not correct. The court approves the amendment, a minor typographical omission which did not prejudice his rights despite the absence of a rearrangement. You notice that the requirement for due process would be for the accused, no, to really be told about the nature and the cause of the accusation. Hazing nagkataon lang na ang pangalan pala nito, typo error, hindi nalagyan ng 3. So the real way that it would be done would be for the public prosecutor or the private prosecuting attorney to make a motion. And usually this can be a motion in open court saying, Your Honor, may we move to amend the information so that the Carding Cruz will have now the suffix of the third. Bakit? Yun po talagang complete name niya. In fact, we have here his, what we call this, his birth certificate. And when he's presented, the defense can always subject him to verification that he is Captain Cruzilli, who was the victim of casing. Okay, there is this motion. Defense counsel, do you have any objection to this little typographical error when the information was normally, hearing none, sige, ano na yan, i-update na yan. May error lang yan. What is the option of the defense counsel? Mag-o-object siya, magdadaldal sa doon. Sasabihin ng you are just delaying this action. So, a smart judge would say, I make a ruling. Amen. You want to consider na motion for reconsideration? Paano ka mananalo? Saan mo dadalhin yun? Yung kasong yun kung mag-motion for reconsideration ka. Gusto mo may rearrangement? Sige, i-arrange natin. Hindi na judge. Pinahihirap mo na lang itong ito. As a good practicing lawyer, you probably will not make that issue. Napakaliit. It will not change the fact that may ginulpi sila under hazing. Kung yan si Carding Cruz III, hindi naman mahirap i-establish yun. Kaya nga nandun siya, nag-ahabla siya. Siya yung siguro lang niya na yung tamang pangalan niya kalagay dito. Under Section 14 of Rule 110, it says, a complaint or information may be amended in form, katulad nun, typo error, or in substance, after the plea and during the trial, with a formal amendment made with leave of court, and when it can be done without causing prejudice to the rights of the accused. The court shall state its reasons for in resolving the motion, and copies of its order shall be furnished all parties, especially the offended party. Definitely will be part of the transcript of stenographic. So that is no big deal. No, even if we go to the motions of rearranging him, doesn't make a big difference. But usually it's no longer a big issue. Usually the defense counsel, if he's smart, will probably not make any issue on that one. Now, I do not understand why this one is not moving towards another question for information. If you don't mind, let me just take a look where the other case of involving the this information is the summons. Doon pa rin mga kaibigan, okay, maiinit. This is jurisdiction. This is Katarungang Pambarangay. This is action. This is kanina natin yung summons. Deposition. Bail, arrest. Okay. Ito. So, we move to this now. This is the second question on information. And it is problem number 12. And we read now. An information for corruption of public officials was filed against Bell. Assistant City Prosecutor Chai, the investigating prosecutor, certified in the information that the same was filed with the prior authority of Jill, the city prosecutor. After the presentation of evidence by both parties, the trial court motu proprio dismissed the case on the ground that Chai does not have the authority to prosecute the case because the information does not bear the signature of Jill or any other indication that she approved the same. The trial court explained that the lack of authority to file an information is a jurisdictional defect that cannot be cured. Is the trial court correct? Explain. Our suggested answer. The trial court is correct to dismiss the case because the city prosecutor should have signed the information to provide authority to Assistant Prosecutor Chai to prosecute the case. This is based on Section 4 of Rule 112. It says, no complaint or information may be filed or dismissed by an investigating prosecutor without the prior written authority or approval of the provincial or city prosecutor or chief state prosecutor. But that should have already been noticed by the defense counsel during the presentation of evidence. And even the judge should have already corrected that, and so that there could not be, the time of the court could not have been wasted. But technically, tumuloy, but the proceedings could not be a valid one because of the absence of the signature of the chief city prosecutor. So that essentially completes the 4 problems under criminal procedure. We are now ready to proceed to the next module. And so when we click criminal procedure, we will be back to our main schedule, which is this one. And it is in here that we see the next module with the civil procedure. And so we click this and we go to the 5 bar questions in civil procedure. The 5 questions revolve around 2 questions in jurisdiction, 1 question in cause of action, 1 question in summons, and 1 question in Katarungang Pambarangay. You notice they were properly distributed, and that's good. Now let's go now to jurisdiction. 2 problems in jurisdiction. Now, the question on jurisdiction here had something to do with the counterclaim. And this is problem number 1. The question reads, Rafael Beatriz filed an action for recovery of the sum of 2.5 million against Tess in the Regional Trial Court of Taguig City. Attached to the complaint was the promissory note, the check issued by Rafael Beatriz to Tess, offering said amount, and a copy of the withdrawal slip of Tess from Banco de Ocho, Rockwell Branch, Makati City. In her answer, Tess raised as her compulsory counterclaim the recovery of her attorney's fees in the amount of 500,000 arising from the case, and a permissive counterclaim against Rafael Beatriz for rescission of contract of sale involving an Arturo Luz painting valued at 2 million. Tess paid the filing fees for her permissive counterclaim. Are the counterclaims within the jurisdiction of the RTC of Taguig City? Discuss your answer. Our suggested answer is yes. The RTC of Taguig City has jurisdiction over Tess' permissive counterclaim to avoid multiplicity of suits after she paid the filing fees. Yun ang objective nun. Kaya tinatagap ang counterclaim. Huwag na masyadong maraming nanganganak yung mga kaso, kung hindi i-centralize na lang, no, may habla, may counter habla, pag-usapan na lang yun in one action before the court. The primary objective of a counterclaim is to avoid and prevent multiplicity of suits, the circuitry of action by allowing the entire controversy between the parties to be litigated and finally determined in one action before the court. Decision in the case of Virginia Dio and HS Equities versus Subic Bay Marine Exploration, a decision made in 2014. Moving on to the second case of jurisdiction is in the area of forum shopping. Question number 4. Hana Corporation or HC is the registered owner of a parcel of land in Capitolio, Pasig City. St. Aaron School, SAS, occupied said lot by mere tolerance since 1992 until December 2018. HC informed SAS that beginning January 1, 2019, it will be charging 100,000 pesos per month for the use and occupancy of the property. SAS refused to pay the monthly rentals, prompting HC to issue a demand letter for the payment of the amount of 4.8 million, representing the unpaid rentals from January 2019 to December 2022. SAS failed to heed the demand of SC. Hence, SC, which holds business in Quezon City, filed the complaint for collection of a sum of money against SAS in the Regional Trial Court of Quezon City. SAS filed a motion to dismiss on the ground of forum shopping since HE had also filed an ejectment case against it before the Metropolitan Trial Court of Pasig. Should the RTC grant the motion to dismiss on the ground of forum shopping? Explain your answer. Ganda nito. So our suggested answer, no. The RTC Quezon City shall not dismiss the collection case. There is no forum shopping because the right, the cause of action, the issue in the collection case is different from that in the ejectment case. Hindi pareho yun. So walang forum shopping. The collection case refers to past rentals being collected. The ejectment case concerns the repossession of the lessor's property as the owner. Those are two separate cases. And the resolution of one, the ejectment, pinaalis, does not prejudice that the past rentals can still be collected. And on the reverse, if there is a success in collecting the collection case in the Quezon City RTC, that does not automatically generate an ejectment order to drive away SAS. That is why there is no forum shopping. From a practical sense, if you are the counsel of the collection case in RTC Quezon City, there is no harm. In the certificate for non-forum shopping, you can mention them if you have not tried any case, except that there is a pending case of ejectment. So, even if, wala namang harm yun, at least you fully disclose. Disclosure is the key. Disclosure is not something that is very prominent in the practice of law, except when you talk about two areas. In insurance, there is a need for to disclose everything. So otherwise, it will avoid the insurance by distorted consent in concealment. Ganon din naman yung concept ng warranties involving both marine insurance and also common carriers involving land transport. Doon na Pero sa accounting, napaka-importante yung disclosure. That is not a legal term. It is more of a professional term required of certified public accountants, yung disclosure. So, if the auditor finds out something, it is his duty to disclose, even if he is not he is not denying his opinion that the audited statements reflect the true performance. But still, there is this information that he would like to disclose. So, there is no forum shopping, and forum shopping under Section 5, Rule 7 of the Rules on Civil Procedure, covered also by the decision on the heirs of Joe-Santos, Mampo, and rendered Mampo versus Josefina Morada, a 2020 case, which revisits the concept of forum shopping as a procedural means to ensure a favorable decision concerning an issue where judicial actions are filed simultaneously with different tribunals. Here, there is also a pahabol here that says, I think this pahabol is simply part of this one. Okay. So, we're done with forum shopping here. We go back to our main schedule. And under civil procedure, we now go to cause of action. Remember, do not forget, cause of action simply refers to the existence of a right. And if that right is violated, that is what is referred to as a cause of action. A reason to question why the right is being violated. So, very basic. Dapat we should master that cause of action. And so the question on cause of action has something to do with misjoinder in an estate settlement. Problem number 3. And it reads, Pauline and Regine had a dispute over a 500 square meter parcel of land that they inherited from their deceased parents, Milka and James. During the barangay conciliation proceedings, both Pauline and Regine agreed to partition the lot in equal shares. As a result, the title to the property was cancelled and new titles were issued in favor of Pauline and Regine as to their respective lots. However, Regine discovered that the lot covered by her title was on the eastern portion rather than the northern portion, contrary to the agreement. Hence, Regine filed a petition for annulment of transfer certificate of title and barangay partition, with prayer for judicial partition of the intestate estate of the spouses Milka and James against Pauline. After trial, the court rendered judgment in favor of Regine. Pauline then consulted a newly minted lawyer, Attorney Terry, who explained to her that there was a misjoinder of causes of action when Regine included both annulment of TCT and the barangay partition as well as judicial partition in the petition. Hence, the trial court erred when it ruled on both causes of action instead of dismissing the petition of Regine. Is Attorney Terry correct? Explain. Our suggested answer is no. Attorney Terry is not correct because a misjoinder of the cause of action does not call for the court's dismissal of the case. The annulment of the barangay agreement and the transfer certificate of title is an ordinary civil action for rescission of a voidable contract. The settlement of the estate of the deceased parents is under special proceedings. So you cannot merge special proceedings with ordinary civil action. The inclusion of the estate settlement is a misjoinder. The court can dismiss said special proceedings from the ordinary civil action and proceed to litigate the estate settlement separately. Kung sabihin niya, tinahal mo, dapat pala dalawa yan. So yung ordinary civil action questioning the validity of the what they call this, of the partition, the settlement is a separate civil action. Babaguhin natin yung agreement nyo to conform with what was really agreed upon. But in terms of settling the estate, that is a different procedure and special proceedings, and we will already consider it as separately filed bill and we will litigate on the basis of joinder of a cause of action. A party in one pleading assert in the alternative or otherwise as many causes of action as he may have against an opposing party. Yun. Precisely to avoid multiplicity of suit. But not to include special civil actions or actions governed by special rules that are under Section 5B, Rule 2 of the Rules on Civil Procedure. So pwede mong pagsama-samahin kung lahat sila naghahablaan kayo nung kabila. Kayo lang magkaaway. Iba-ibang mga rights na na-violate. Provided they do not include cases which requires a different proceedings like special proceedings or special civil action. Then iba ang proseso. So that is the question on cause of action in civil procedure. We go now to the question on summons. And I remember very clearly that we were reminded, summons is always with an S, parating plural. Walang summon, walang singular ang summons. Okay? So, the question on summons na has something to do with publication. This one is very interesting because I had an experience doing this. Anjan and Pam were married in 1996. However, in November 2003, Pam left for the United States due to her alleged irreconcilable differences with Anjan. In 2020, Anjan filed a petition for the declaration of nullity of his marriage with Pam before the Regional Trial Court of Makati City, where he resides. Subsequently, Anjan filed a motion for issuance of summons by publication because Pam already resided abroad. The RTC issued an order dated August 27, 2020, granting the motion and directed the summons to be served upon Pam by publication in the newspaper of general circulation in the U.S. However, the copies of the order, summons, and complaint were not served at her less known address Meanwhile, no answer was filed by PAM. Thus, the RTC rendered the decision granting the petition, which eventually became final and executory. Was the August 27, 2020 order of the RTC proper? Explain your answer. Our suggested answer is yes. The RTC order of August 27, 2020 is proper because defendant PAM does not reside and is not found in the Philippines, and the action affects the personal status of plaintiff and judge. When the defendant under Section 17 Rule 114 reads, when the defendant does not reside and is not found in the Philippines, and the action affects the personal status of the plaintiff, service may, by leave of court, be effected out of the Philippines by publication in a newspaper of general circulation in such places and for such time as the court may order. In which case, a copy of the summons and order of the court shall be sent by registered mail to the last known address of the defendant or in any other manner the court may deem sufficient. Any order granting such leave shall specify the reasonable time which shall not be less than 60 calendar days after notice within which the defendant must answer. So, tama. Pagka nawawala na rito, alam na umalis eh. I-serve na yung by publication. And to make sure if that particular person has a known address, definitely there is a last known address. Preferably, you can address that particular publication, summons by publication. You provide now a copy to the counsel. And the counsel now locally will be recognized as you're having complied with the requirement of due process. Pero at the same time, make the publication be distributed to the place where she is known to be staying in the United States. Some would even make a publication also in the US, in the vicinity or in the area where the person is heard to be staying. Next would be the last problem under civil procedure, and ito halos sa jurisdiction issue on the Katarungang Pambarangay. The question on Katarungang Pambarangay runs like this. Problem number 2. Trinca borrowed 1.5 million from Ida. Trinca executed a promissory note promising to pay Ida in 3 equal monthly installments. When Trinca failed to pay her obligation, Ida filed an action for recovery of the sum of money against her in the Metropolitan Trial Court of Pasay City. The case was referred to Judge Risa, who upon reading the complaint noticed that Trinca and Ida were neighbors in Barangay 189 in Pasay City, and that there was no prior referral of the case for barangay conciliation. Hence, Judge Risa dismissed the case motu proprio for failure to comply with the condition precedent. Was the dismissal of Judge Risa proper? Explain your answer. Yes, Judge Risa's dismissal is correct because no prior referral for barangay conciliation is failure to state a cause of action. Wala kang right to file action on any violation of your right if you did not follow the requirement on barangay conciliation. And under Section 412A of the revised Katarungang Pambarangay and supported by Section 1, Rule 21 of the Rules of Court and also these decisions of the Supreme Court had opportunity to say that a case filed in court without compliance with prior barangay conciliation, which is a precondition for formal adjudication, may be dismissed upon motion of the defendants, not for lack of jurisdiction of the court, but for failure to state a cause of action or prematurity, or the court may suspend proceedings upon petition of any party under and refer the case motu proprio to the appropriate barangay captain. So pwede palang hindi i-dismiss lang. Sabihin lang, suspend muna natin. Sige, bumalik kayo sa barangay and you now refile your certificate to file action here coming from the barangay kung hindi kayo nagkasunod. That essentially covers the 5 questions on civil procedure under the procedural remedial law that was given in September 2023. So we've already covered 2 major modules under this. We are now about to go to the most beautiful module on evidence. And there were 6 problems that were given on evidence. Let's take a look at them. The problems that were given in evidence are broken down into 1, 4 in testimony, 2, 1 in legal forms. The other one is in disposition. So 4, 5, and 6. So let's take a look at your testimony of your witnesses. Okay. The first problem under testimony is problem number 13. Raisa filed a case for support against Ton on behalf of their 9-year-old daughter, Rox. During trial, Rox was presented as a witness. The counsel of Ton invoked the rule on incompetence of Rox to testify against her father given her tender age. The trial court allowed Rox to testify. Is the trial court correct? Explain briefly. Our suggested answer. The trial court is correct in allowing Rox, a 9-year-old daughter of the accused, to testify. A child is presumed to be qualified as a witness because he can perceive and relate the perception to others. She is competent to say that her father failed to provide her support. In the case of Petitioner versus People of the Philippines, a 2023 case, accused Ton's 9-year-old daughter testified as a competent witness against her father's failure to provide support. So this is not something that we invented, but already decided by the Supreme Court. In Section 6, Republic Act 7610, on the examination of child witnesses under the Special Protection of Children, every child is presumed qualified to be a witness. And so that is the first, that is the first question on testimony referring to the maturity of the child. The next question on testimony is a question on evidence for conviction. This one is very interesting. Problem number 14. In a criminal case for murder filed against Erica, the prosecution presented Chell as an eyewitness to the killing of Lai. Chell testified that while the 3 of them were on board a boat, Erica shot Lai with a .45 caliber pistol and threw both the gun and the body of Lai into the sea. Efforts to retrieve the gun and the body of Lai were unsuccessful. Evidence was likewise introduced to prove that Lai was thrown in a shark-infested area. Erica consulted her nephew Ted, a recent law school graduate who is reviewing for the bar. Confident of an acquittal, Ted recommended that Erica file a demurrer to evidence, meaning no evidence at all, because there is no corpus delicti due to the failure to recover the gun and the body of Lai. And number 2, the prosecution failed to prove that Erica fired the gun due to the lack of a paraffin test. Is Ted correct? Discuss. Our suggested answer, and lifted from the case of People versus Solar, a 2019 case. No, Ted is not correct. There is corpus delicti despite the failure to recover Lee's body and the gun. The close link in the circumstantial evidences comprises the corpus delicti. The body is not the singular determination of corpus delicti in a crime against persons. Credible witness Chell, number 1, personally knows the accused Erica and victim Lai. Number 2, she saw Erica holding the .45 caliber pistol. Number 3, she saw Erica shoot Lai with the said pistol. And number 4, she saw Erica throw Lee's body and the gun into the sea. Chell has no motive against Erica to relate the specific point she saw. Lee's body cannot be found because it was thrown into a shark-infested area. The lack of paraffin test cannot disprove Chell's testimony that she saw Erica actually shoot Rai. So it doesn't always mean that there is no evidence at all when the body cannot be found. Some people think that the dead body is represent the corpus delicti. Well, if you have the dead body, that is a very strong corpus delicti. Patay eh. Ayun, namatay. That is what you're trying to establish na may pinatay. At sino yung pumatay. Now, if that particular body is not there, then the series and interconnection of what are called circumstantial evidences will come in. And therefore, the testimony of a lone eyewitness will become now the circumstantial evidence. First circumstance, nandun siya at the scene of the crime. And she knows who Erica is and who Lai is. She knows the accused and she knows the victim. She saw the shooting and she saw the throwing overboard. And so unless they can prove that she has any ill motive to testify on what she saw, that particular testimony now partakes of the corpus delicti, the body of evidence to prove that there was really this kind of offense against a person's life. So, kung titingnan mo yung patay na body, tama yun, corpus delicti. It consists of the primary evidence to prove death. But if you cannot have that, the series of circumstantial evidences that will point to the killing of that victim will also be considered as corpus delicti. So corpus delicti refers to the evidence, no? At nagkataon, yung body na corpus din talaga, it becomes the strongest source of evidence. That's why, pag sinabi mo, nandyan yung katawan ng patay na tao, may corpus delicti ka. Hindi, you're not referring to the body per se. You are referring to the dead body that establishes a crime of homicide that this was committed. Napaka-exciting yung concept na yan. Ako mismo, dati akala ko, corpus delicti, corpus kasi body mo pinatay. Pag nawawala, hindi wala kang corpus delicti. No, corpus delicti refers to the evidence to prove that there is a person who was killed. And the dead body is the strongest evidence. Hindi yung corpus na body, kung hindi yung mismong existence of that dead body becomes the corpus delicti. Ganda. And then we now go to we have four issues on testimony. Ito, testigo na naman yung hearsay evidence under problem number 15, and it refers to dying declaration. Ito basic. While relaxing one Sunday afternoon, Kesh suddenly felt sick. While she was on the verge of losing consciousness, Kesh called for Robert, her personal nurse, who was told, "Call Dr. Nancy forthwith." Robert asked Kesh about what happened, and Kesh further relayed, "I am probably going to meet my creator. I ate the instant noodles prepared by my husband last night, and I think he put poison into it." The following day, Kesh passed away. The certificate of death issued by the medical legal officer who conducted the autopsy reflected the cause of her death as aneurysm or rupture of a blood vessel. Later, the husband of Kesh was prosecuted for murder. Dapat hindi murder, dapat parricide. During trial and apart from the medical legal certificate, the prosecution also offered in evidence the testimony of Robert to prove the utterance of Kesh. Is the statement of Kesh admissible as a dying declaration? Explain. Our suggested answer is yes. Kesh's dying declaration to Robert is admissible in evidence. She made the declaration to Robert while conscious of her impending death, and the cause and circumstances of her death is the subject of inquiry. Under Section 36 of Rule 130, under the rules on evidence. It reads, a witness can testify only to those facts which he knows of his personal knowledge, that is, which are derived from his own perception, except as otherwise provided in these rules. And it is in Section 37, Rule 140, that the dying declaration is mentioned as one of the exceptions, part of the hearsay rule. It reads, the declaration of a dying person made under the consciousness of an impending death may be received in any case wherein his death is the subject of inquiry as evidence of the cause and surrounding circumstances of such death. So that is the authority, Section 37, to admit a dying declaration. The last problem in testimony, problem number 16, has something to do with pedigree declarations on relationship. The problem reads, Banji filed an action for compulsory recognition with prayer for support against J, her putative father. During trial, she presented and identified the following documents of the witness's stand. Number 1, birth certificate of Banji reflecting J as the father of Banji, per information supplied by the mother of Banji but was unsigned by J. And number 2, letters from the siblings of J addressed to private schools where Banji was enrolled, which attested that J is the father of Banji and that he regularly supports her education. Ruled on the admissibility and sufficiency of the documents as evidence of acts or declarations about pedigree. Explain briefly. Our suggested answer, yes. Banji's documents on her relationship with J as her father include number 1, her mother's declaration in her birth certificate that J is her father when there was no controversy about recognition and support. Hindi pinag-aaralan, spontaneous sinabi ng nanay. And number 2, J's support for Banji's education declared by J's siblings. These facts will allow Banji to claim her pedigree with her father, J. Under Section 39 of Rule 130, it reads, the act or declaration of a person deceased or unable to testify in respect to the pedigree of another person related to him by birth or marriage may be received in evidence where it occurred before the controversy, and the relationship between the two persons is shown by evidence other than that such act or declaration. The word pedigree includes relationship, family genealogy, birth, marriage, death, the dates when the places where these facts occurred, and the names of the relatives. It embraces also facts of family history intimately connected with pedigree. So pag sinabing ikaw shiatsu, ikaw for example German Shepherd, kung nagsabi nun yung nanay mo na wala namang away, German Shepherd ka siguro talaga. Okay. So, that essentially covers testimony. Now, we will first talk about deposition on the left before we go to legal forms. In the case of deposition, under evidence, there is a question on when do you use deposition, and this is something to do with the celebrated case. The problem reads, Clarice and Myra offered Gaita a job as a domestic helper in Indonesia. Clarice gave Gaita her plane ticket and luggage to bring on her trip. Upon reaching the airport at Yogyakarta, Indonesia, she was apprehended by the police for allegedly carrying 2 kilograms of heroin inside her luggage. She was then charged before the Indonesian courts with drug trafficking and subsequently convicted and sentenced to death by firing squad. Meanwhile, in the Philippines, Clarice and Myra were arrested and charged with qualified traffic of persons, illegal recruitment, and stapa in the Regional Trial Court of Angeles City. Gaita was given an indefinite reprieve by the Indonesian government to give her the opportunity to testify in the case against Clarice and Myra. Hence, the people of the Philippines, through the Office of the Solicitor General, filed a motion to take the testimony of Gaita upon written interrogatories under Rule 23 deposition pending action of the rules of court. The RTC granted the motion of the OSG. Was the action of the RTC proper? Discuss your answer. Our suggested answer is yes. The RTC's grant for the Solicitor General to take Gaita's testimony in written interrogatories of a deposition is proper. Gaita's deposition de bene esse is to allow Gaita's testimony for the pending qualified traffic versus Clarissa and Myra to be considered even when she is out of the Philippines beyond her control. The Supreme Court allowed Mary Jane Veloso's written interrogatories because of her right to due process. Her Indonesian imprisonment with the conditions attached to her reprieve denied her the opportunity to voluntarily appear and testify before the trial court where the respondents' cases for illegal recruitment were pending. This was the celebrated case of People of the Philippines versus Maria Cristina Serio and Julius Lacanilaw, a decided case in 2022. And so the last question on evidence has something to do with the requirement to prepare a deed of absolute sale of land. So it reads, number 20, Edsel A. Flores, a resident of Bacoor City, Cavite, sold to Joel R. Vargas, a resident of Binondo, Manila, a parcel of land located in Bacoor City, Cavite. The parcel of land in an area of 500 square meters and was covered by a clean original certificate of title number 1234567 issued by the Register of Deeds of Cavite. The purchase price amounts to 8 million. The parties agreed that the seller shall bear the capital gains tax, real estate tax, and documentary stamp tax, while the buyer shall bear the rest of the expenses, prepare a notarized deed of absolute sale. Our suggested answer is in a draft deed of absolute sale. And it says deed of absolute sale of registered land. Yung dating title, No All Men by This Presence, is an old-fashioned one. The more modern one is Let All Know. That's exactly what it's meant by No All Men by This Presence. No, Let All Know. And you have there the name of the seller, Edsel Flores, the requirement of Filipino citizen, of legal age, married, and then the resident. And of course, the buyer, Vargas, Joel Vargas, same name, Filipino citizen, legal age. And then you say now, have mutually agreed to enter into a hearing deed of absolute sale of a parcel of registered land located at Bacoor City by virtue of the following terms and conditions. Ayan. So, seller Flores, absolute owner, fee simple, registered land consisting of 500 square meters under the original title, very important, which the Cavite Register of Deeds issued, it said none more particular. Ito, very basic. There has to be a copying of the technical description on the title. No? So, parcel of land, define kung saan yung mga boundaries. So, pagkatsagaan lang yan. Kaya mahal sumingil pagka deed of absolute sale ang ginawa mo when you are the counsel. Second, that seller Flores and buyer Vargas agreed on the net selling price of, and nalagay mo doon, in Philippine pesos, and you now acknowledge receipt of which seller Flores duly acknowledges. And then here, it would be good to have a third paragraph where you divide the incidental expenses between the seller and the buyer. So here, under seller Flores, for the BIR, the capital gains tax. Siya nagbebenta eh. Diba? So siya liable. But in the case of Vargas, to the Cavite Treasurer naman, yung transfer tax. Dahil malilipat sa kanya, siya ngayon ang babayad ng transfer tax. In the case of Flores, the seller, he will also have to pay the documentary stamp tax on the deed of sale. And then finally, he will have to reckon with the real property tax, yung amilyar, dapat updated. Unless they have an agreement that if there is any shortfall, it will be already for the account of the buyer. But technically, it is supposed to be for the seller. Then when he sells the land, it is already clean of all taxes in arrears. In the case of the buyer, he will have to pay, of course, the registration and related fees to the Register of Deeds. Siyempre. And then, ang question yung notarial fee. Magbabayad yung documentary stamp tax yung seller. Pero yung notary naman, normally naman, dapat naman yung buyer. Kasi siya yung gustong merong title to the property. And then, this one is something that may be worthwhile putting. Several forest warrants, that there is no pending cases or any legal impediment sana or hindrance for buyer Vargas to acquire the subject property of the instant deed of sale. With or without this, that is covered by the civil code on the warranties of the seller. And then of course the date, signature, tapos merong witnesses. Normally, dapat dito, hindi ko lang magawa by way of putting signatures. Dapat sa left side margin should also be the signature of both the seller and the buyer and preferably their witnesses. Then finally, hindi makakalimutan, dapat merong acknowledgement. Hindi jurat. Pagdating sa deed of sale, doon ginagamit ang acknowledgement. Before me, as part of the public, forum within Cavite City, ayun, Edsel Flores and Joel Vargas, no? Personally known to me and known to be the same person who executed the deed of sale. So, dapat mag-appear yun talaga. No? Nakalagay 3 pages, nakalagay yung pangalan ng dalawang AFIAN. Pwede mo rin lagay witness kung gusto mo. Identification number, you know this, that is supposed to be a government-issued ID with your picture in it and signature preferably. Then, sign in witness row, I about to take my signature and seal. Ito, Sopronio Blando, Notary Public, PTR number, Cavite City, roll of sale. So this represents now the requirement as to form. Talaga naman dapat meron man lang isang form na alam yung kukuha ng bar para alam niya na kailangan kabisado niya yung mga forms that he will have to deal with when he becomes a lawyer. And so that is, those are the subject matters of evidence. Konti na lang. Special civil action and special proceedings. So we have this, yung unlawful detainer. And the problem on unlawful detainer runs like this. Ejectment, number 7. Kaina, a resident of Antipolo City, is the registered owner of a house and land located in Tondo, Manila, with an assessed value of 900,000. Kaina claimed that she allowed Sarah, her sister-in-law, to stay in the house out of compulsion. Years later, Kaina decided to distribute the property to her children, so she demanded that Sarah vacate the premises. However, Sarah ignored the demand. She even filed the case against Kaina, questioning her ownership of the property and contending that she obtained title over the property through fraud, deceit, and falsification. On August 23, 2023, Kaina sent a formal demand letter to Sarah to vacate the property, but this remained unheeded. Kaina wants to commence an action against Sarah no later than May 16, 2024, before Kaina leaves and temporarily stays in the United States. If you are the counsel of Kaina, what action will you file, where, and in what court? Explain briefly. Our suggested answer. Kaina's action is ejectment for unlawful detainer before the Metropolitan Trial Court, Manila. Occupant Sarah's possession was initially legal because of Kaina's permission. The possession has become unlawful when Kaina no longer allowed Sarah's possession because the owner has legitimate right to use her property. Action for ejectment on unlawful detainer is under the exclusive jurisdiction of the Metropolitan Trial Court of Manila, where the subject property is located. And so that is the question on unlawful detainer. That is a special civil action, and the subject matter on special proceedings would be changed of name. The problem given under change of name looks like this. Problem number 8. In 2014, Karina filed before the Regional Trial Court a petition for change of name under Rule 103 of the Rules of Court to change her first name, include her middle name, and correct the spelling of her surname from Karen Lapus, as stated in her birth certificate, to Karina Garcia Lapus. According to Karina, she has been using the name Karina Garcia Lapus since childhood. Will the petition of Karina prosper? Explain your answer. Our suggested answer is no. Karina's petition may not prosper because number one, there is no reference being made as to her being a bona fide resident of a specific province or place. Dapat ilagay yun so they will know na ito pala, kilala pala dito, ganito. Number two, no mention on the cause or reason for change of name. And number three, no publication as to the purpose of the petition for a change in name. Under Section 2 of Rule 103, a petition for change in name shall be signed and verified by the person desiring his name change or some other person on his behalf, and shall set forth, letter A, that the petitioner has been a bona fide resident of the province when the petition is filed for at least 3 years prior to the date of such filing. Wala yun. The cause for which a change of the petitioner's name is sought, wala. Ang sinabi lang, matagal na niyang ginagamit yung pangalan ninyo. And then the name asked for. Yun. So that is the answer. It does not fit into the requirement of a change in name that will be approved. And finally, our last module under remedial procedural law are the questions on legal and judicial ethics. The questions that were asked, number one, is acquiring interest object of litigation, number two, conflict of interest, and number three, judicial ethics. Tingnan natin muna itong acquiring interest object of litigation. Under the concept of, this one went into Supreme Court Administrative Suspension, Conflict of Interest, Execution, Sale. Problem number 17. The Supreme Court suspended Attorney Iris for 1 year in an administrative case filed against her for gross misconduct. During the effectivity of her suspension, Janet appointed her as attorney-in-fact in an execution sale arising from a civil case that she previously handled. At the execution sale, Attorney Iris took part in the bidding and negotiations as regards the payment of the judgment award. Attorney LB, the opposing counsel in the civil case, questioned the appearance by Attorney Iris during the execution sale because of her suspension. Attorney Iris argued that she was merely acting as an attorney-in-fact of Janet, which was not tantamount to the practice of law. Do you agree with Attorney Iris? Explain your answer. Our suggested answer is no. Attorney Iris is essentially in the practice of law. As attorney-in-fact in the execution sale, she shall necessarily undertake her role using a knowledge of the law. Her engagement by the former client allows her tremendous advantage by reason of the relevant legal provisions and the attendant facts which she learned from her earlier engagement. So Attorney Iris is effectively in law practice despite her suspension. Under Section 1, Canon 3 of in the practice of law, the practice of law is the rendition of legal service or performance of acts or the application of law, legal principles and judgment in and out of court with respect to circumstances or objectives of a person or a cause. Second problem under legal ethics is the concept of conflict of interest. Here in problem number 18, it reads, Kiko engaged the services of Attorney Benito for an ejectment case against illegal settlers occupying his property in Caloocan City. After one of their hearings, Kiko hurriedly walked to his car. When Attorney Benito asked him where he was headed, Kiko responded, "Uwi na ako, attorney. Galit si Mrs. kasi nakalimutan ko anniversary namin." At that time, the marriage of Kiko was on the rocks. Kiko eventually won the ejectment case against the illegal settlers, which also marked the termination of his retainership agreement with Attorney Benito. A few months later, Kiko received summons in a petition for declaration of nullity of marriage filed by his wife Nena through her counsel Attorney Benito, who signed the petition. Is Attorney Benito guilty of representing conflicting interests? Explain. Our suggested answer is yes. Attorney Benito is guilty of representing conflicting interests. Kiko, the husband, was Attorney Benito's client in the ejectment case. He cannot handle the marriage nullity case of Nena, Kiko's wife. The property which Benito recovered for Kiko as part of the absolute community for which he will be fighting in behalf of Nena's interests. Nena's interest as a prospective client in the property recovered is materially adverse in Kiko's interest as a former client. Section 18E, Prohibition against Conflict of Interest. Unless the former client gave written informed consent, a lawyer who has represented such client in a legal matter shall not thereafter represent a prospective client in the same or related matter, where the prospective client's interests are materially adverse to the former client's interests. Yeah. And our third question on legal and judicial ethics is a question on judicial ethics. The problem reads on judge misconduct, Supreme Court authority. This is very important. Problem number 19. Romy filed an administrative complaint against Judge Ferdi with the Office of the Ombudsman in relation to the bribery he allegedly committed as a presiding judge of a regional trial court. After investigation, the Ombudsman found him guilty of grave misconduct and imposed penalty of dismissal from service. May the Ombudsman dismiss Judge Ferdi? Explain. Our explanation, I suggest the answer is yes. The Ombudsman may dismiss Judge Ferdi for bribery under the Anti-Graft and Corrupt Practices Act. For graft cases, members of the judiciary are placed on the same level as all other government employees, where the Supreme Court exercises no exclusive jurisdiction. In the case of Judge Martin A. Ocampo versus Sunstar Publishing, a 2000 Supreme Court decision, the Supreme Court had the opportunity to say, the criminal nature of the Anti-Graft and Corrupt Practices Act to include bribery offers no protection to the judiciary, who are placed in the same level without distinction with other government employees. Graft violations are serious in nature, an endemic social cancer eroding our system of government. The Anti-Graft Ombudsman has jurisdiction under Republic Act 6770, which is the Ombudsman's Act of 1989, on complaints against all government officials, even impeachment proceedings. And so that basically completes the 20 questions given in remedial procedural law. And again, I just wanted to remind everybody that this particular upload is dedicated to none other than the President of the University of Manila, Dr. Emily Dadson de Leon, our incumbent President, Chairman Board of Trustees, the Academic Vice President, and the icon, the heart and the strength of the University of Manila. And we are proud to be working with her, a very sincere person, a person who gives everything that she has in order to defend this institution that she has come to love and has become the symbol of this particular institution. So Dr. Emily Dadson de Leon, marami pong salamat for allowing me to be working with you, to have reappointed me as the Dean of the College of Law. And I guess some of us would be with UN for a long, long time until we can still afford to think and to act in behalf of this institution we have loved so much. So again, we are proud of you, Dr. Emily Dadson